This courtroom moment is a powerful reminder that probation is not a suggestion, it's a legal obligation. In this tense hearing, a 28-year-old defendant stands before the judge after repeatedly violating the terms of his probation stemming from a family violence case. What should have been a chance to stay free quickly turns into a confrontation over accountability, honesty, and responsibility. As the court reviews the violations, the list keeps growing. Failed alcohol testing, missed counseling, unpaid fines, and complete non-compliance with court-ordered programs paint a picture of someone who ignored every opportunity given to him. The defendant tries to explain himself, claiming financial hardship, unemployment, and even blaming a positive alcohol test on cold medicine. But the court isn't buying it. The judge responds with a firm and unforgettable lecture, calling out the excuses one by one. She makes it clear that being young and able is not a disadvantage, it's an opportunity. From free recovery meetings to finding work wherever possible, the message is blunt: excuses don't replace effort. The courtroom shifts from explanation to consequence as the judge emphasizes that probation only works when the defendant takes it seriously. By the end of the hearing, the warning couldn't be clearer. This is not just about missed appointments or unpaid fees. It's about refusing to grow up and take responsibility. With jail time now imposed, the judge delivers a final message that echoes through the courtroom: this is the last wake-up call, and the next failure will cost him his freedom entirely.
For this court for battery family violence, simple battery family violence, and simple battery family violence. On the 19th day of February 2024, you were sentenced to 24 months on probation. You have 1 month and 15 days remaining on the first case, 2023 CR 07318, and 12 months on the consecutive case, 2021 CR 00449. This is your second hearing, and the sentence was not told. Says you failed to avoid injurious and vicious habits. You tested positive for the metabolites of alcohol. You failed to comply with counseling. So you failed to do the family violence intervention program. You failed to attend NA or AA. You failed to complete risk reduction program. You failed to complete community service, and you failed to pay your currently $2,880 in arrears. Wow, sir, you have wasted 11 months and done nothing. So tell me what's going on. Why?
When I came to see you, I had told you I wasn't working. I was out of work. So all the things that I really have to pay for, I didn't have the money to do. And like I was just telling my attorney here that I just recently received a job, like back in November.
AA is free, and staying off, not drinking is free.
Like I said, I've been everything that I have to pay for, I haven't attended to because I just didn't have the money to do it. I've been doing my.
Okay, how many times have you gone to AA?
I don't have my log. I've been doing.
You just don't have what?
I don't have my log, so I can't really give you an exact number, but I've been doing my AA meetings like once a week as told to me to do so. So I've been doing my AA meetings.
Okay, well,
put that aside, Judge.
Even if we ignored all of that, Mr. Beck has done bupkis, and this is his second hearing, and he tested positive for alcohol. How old are you, Mr. Beck?
28.
Mr. Beck, you're 28 years old. Is this going to be your life?
No, ma'am.
Red jumpsuit?
No, ma'am.
It's starting to be, Mr. Beck. I got 2 cases in front of me. You basically have done nothing on probation. This is your second hearing. So I feel like you're okay with this.
I'm not okay with it. Like I always been trying to do my best with doing what's been asked of me to do.
No, sir. See, just trying to do your best. You're 28 years old. You're a grown man. If you were trying to do your best, then we wouldn't be happy.
You're saying, but if it's hard for me to find a job, what more do you want me to do about the classes that I have to
What
take?
you looking for, Mr. Beck? What kind of job we talking about?
Any job that'll accept me to come and work for them. So,
Mr. Beck, you obviously don't know about the legal hustle. Mr. Beck, do you know I can sew? I can braid. I can lay concrete if I have to. I can do lawn work. I have driven a backhoe. I have driven a dump truck. I have graded a road using said backhoe. All of this is self-taught. I have put shingles on a roof. All of this. And I'm not no big girl. I'm like 5'2". So I have learned all of these things. If I can figure out how to, I put a gas line in a hedge trimmer one time because I needed a new gas line to make the hedge trimmer work. I figured it out. So, Mr. Beck, if I can figure out how to do all of these things, and I got a law degree, you can figure out how to do some jobs. You can do some jobs. You don't have to get a job where somebody's hiring you. They need people to do all kinds of stuff. There's people doing roofing work, plumbing work. Even if you don't know how to do it, they need somebody to haul away scrap. Okay, can I come by and pick up the scrap and move that out of the way for you? There's things you can do. Mr. Beck, a little ingenuity. I'm going to need folk in your age group to stop acting like y'all are helpless. Y'all been babied. Y'all have been babied. I'm going to just tell you, I'm from that old school, the one where your mamas ain't doing for you. They going to push you out of the nest and make you figure out how to do stuff. Find something. All these jobs you're looking for, okay, then figure out how to earn $1. Offer to do some work for somebody. Yo, man, can I help you pick up this concrete or lay concrete or pick up this plywood or clean up this work site so I can make $1? I'm just tired of y'all 20-somethings coming before me and y'all just don't do nothing. And then in all of this, knowing what you have, then you decide to go do.
The only reason why that.
Well, what happened? Did somebody pour some down? You had, oh, wait, let me get. Did you have vodka pasta or rum cake?
Neither. I was just sick and I just went for what I knew is taking simple medicine, and that's really what it is.
No, sir. No. I'm not buying the medicine, the NyQuil. I'm not.
All right. Well, that's the only excuse I have because I really don't even drink like that. As he was just trying to figure out as to why I have to take DUI classes with no record of me doing anything. Alcohol or drugs.
Okay. I see Mr. Lynch has given you an idea about how to talk to me about your case. Okay. Even if we skip the DUI program, you ain't done nothing else.
Your Honor.
Yes, sir.
I would just point out that he was given a 24-month sentence. So he has a whole nother year in which he can prove to this.
No. So, Mr. Lynch, this is the thing that I don't like people saying. Okay, I'm gonna waste the whole first year, so I got the second year to do right. No, if you wanted to show me that you want to be done, then do it all in the first year, and then the second year I say, hey, we don't need to do this the second year because he did everything. He showed me that he really wanted to be off probation. He showed me that that this had an effect on him. So no, I'm not doing. I'm gonna take. Will you say 180 days, Ms. Chang?
120, Your Honor.
It sounded like you said 180 because that's what I'm hearing. But this is the second hearing, Mr. Lynch. I'm just tired of second hearings. I'm tired of people who play me the first time and then come back and tell me about all the children they supporting. If he wasn't able to support himself and do anything, he ain't supporting them kids. Their grandparents are. Whoever the mama is living with her mama and they supporting these kids. Where your kids living, Mr. Beck?
They live with my baby mother and they have their own apartment. She has her own place.
And she's probably on assisted living if she's not working and sufficiently to support them. But you're not supporting them. So I'm this whole thing of, well, I'm supporting my kids and please.
He's not claiming to be the sole provider.
No, I hope the Lord he's not. I mean, I did put him under oath at the beginning of this.
Right.
Mr. Beck, I'm going to teach you that you don't need to be trifling anymore. I just really, you're going to need to start standing up and being a man. That 120 days is sounding real good. Yeah, let's get this 120 days. And then after that, we'll suspend as long as there's no violations, we'll suspend the remainder of the term. But that means that if you mess up, then you'll come back to me and I still have 12 months or whatever left to play with. So yeah, 120 days will be.
The courtroom is quiet as the defendant stands before the judge, facing a reality he's been avoiding for months. At just 28 years old, he was given probation instead of jail after a family violence battery charge, a second chance that came with clear rules and expectations. This hearing exists for one reason only: to determine whether he respected that chance or wasted it. From the moment the judge begins reviewing the file, the direction of the case becomes clear. Probation was never meant to be easy, but it was meant to be manageable. The court ordered him to remain alcohol-free, attend counseling and recovery meetings, complete a family violence intervention program, perform community service, and stay current on court-ordered payments. These were not random requirements, they were designed to protect the public and give him a path forward. Instead, nearly every condition was ignored. The judge addresses the failed alcohol screening first. Despite a direct order to abstain from drinking, the defendant tested positive for alcohol metabolites. This is not a minor technicality. Alcohol use was specifically restricted because of the nature of the underlying offense. The court reminds him that probation requires honesty and compliance, not creative explanations after the fact. The list continues. He never completed the required family violence intervention program. He failed to attend risk reduction classes. Community service hours remain unfinished. Thousands of dollars in fines and fees are unpaid. Mandatory or NA meetings that cost nothing and exist to help, were skipped entirely. With each violation, the courtroom tension grows heavier. This is no longer about one mistake. It's a pattern. When the defendant is allowed to speak, he doesn't deny the violations. Instead, he attempts to justify them. He explains that he was unemployed and couldn't afford the programs. He claims he attended recovery meetings but lost the log that would prove it. He insists that the positive alcohol test came from over-the-counter medicine taken while he was sick. Each explanation sounds less like accountability and more like an attempt to escape responsibility. The judge listens carefully, but her response is firm and unflinching. She makes it clear that probation is not about convenience. Being unemployed does not excuse non-compliance. Free meetings exist in nearly every community. Odd jobs exist for those willing to look. Transportation challenges, financial hardship, and personal setbacks do not eliminate personal responsibility. The court expects effort, not perfection, and effort is exactly what is missing here. She speaks directly to the defendant's age, reminding him that 28 is not a child. At this stage of life, society expects adults to solve problems rather than surrender to them. She challenges what she describes as a helpless mindset, pointing out that countless people manage probation while facing far greater obstacles. The courtroom remains silent as her words cut through every excuse offered. The judge shares her own experiences, not as a lecture but as a comparison. She describes learning manual labor, working difficult jobs, and doing whatever was necessary to survive and succeed. Her message is unmistakable: life does not pause for hardship, and the law certainly does not. Responsibility does not disappear when circumstances become uncomfortable. She returns to the issue of honesty. Losing paperwork is not compliance. Blaming medication for alcohol use is not proof. Probation relies on documentation, follow-through, and effort. Without those things, trust disappears. And once the court loses trust, consequences follow quickly. The judge emphasizes that probation is a privilege extended by the court, not a guaranteed right. It exists to give people an opportunity to correct behavior without incarceration. But when someone repeatedly ignores the rules, the court has a duty to respond. Public safety, accountability, and respect for the law demand it. As the hearing reaches its breaking point, the judge delivers her decision. She revokes 120 days of the defendant's sentence, ordering him into custody. The ruling is direct and final. There is no argument left to make. But the judge doesn't stop there. She issues a warning that resonates far beyond this courtroom. She tells him that this is the last wake-up call. That the remaining 24 months of his sentence are real, enforceable, and waiting. If he appears before the court again with the same excuses, the outcome will be far worse. The system will not continue offering chances to someone who refuses to take them seriously. The defendant stands silently as the weight of the decision settles in. This hearing was never about paperwork, fees, or missed meetings. It was about choice. Every missed class, every skipped meeting, every unpaid obligation was a decision. And today, the court responds with its own decision. The judge's final words make one thing unmistakably clear: growing up is not optional. Responsibility is not negotiable. And probation is only effective when the person on it decides to take control of their own life. The consequences of ignoring the truth are now unavoidable. The courtroom moves on to the next case, but the message remains. Probation is a second chance, and when that chance is wasted, the system responds swiftly. For this defendant, the time for excuses has ended, and the reality of accountability has begun.